Hello, my name is Natalia Grice, and I am a Florida attorney. And let's talk about tax deeds. Specifically, let's talk about what are some of the reasons that tax deeds can be challenged. That's right. Your tax deed can be challenged, which is why those clear to sell certificates are garbage. That's right. I'll say it again. They are garbage. And here's why they can be challenged. So I'm going to go over the simple reasons they can be challenged, and then the more complex reasons that they can be challenged, and the reason why you need to quiet title to your tax deeds without fail. All right. So easy reasons why a tax deed can be challenged. Date of sale happens, and it turns out that the person had redeemed the outstanding tax certificates and it just hadn't been updated in their system. So they paid the outstanding taxes before the sale took place. That's number one. It's the easiest reason. It's in the statute, very clear. They paid those taxes owed prior to the sale taking place. And I have seen this. I have seen it happen in my many years of practice in which somebody pays. It didn't show up on time in the system for the clerk, especially if they paid the morning before the sale and the sale took place accidentally. So in that case, that tax deed is void. Void. There's nothing you can do about it. You'll get your money back. The clerk will give you the money. Very simple. That's the number one easiest thing. Number two, let's talk about the challenges that non-owners can make. So this is if there's a lien holder of record, a bank, a homeowners association, a credit card judgment creditor, anybody who would otherwise be wiped out by the tax deed if they didn't get sent a notice. I say sent, not received, because received is not the same by law under Florida statute. If you didn't receive the notice, but it was sent to you, the clerk complied with their due process requirements. So, and we'll talk a little bit about due process requirements because this is the real big reason why quiet titles are essential. So if there is a lien of record, a homeowner association liens, a mortgage, a second mortgage, like I said, a credit card judgment, those, and they're there and they are an actual lien on the property. How do you know if they're a lien on the property? They attach to the property by virtue of the legal description, or they attach to the property by virtue of the owner of the property having a lien against any and all of their assets. This also includes the IRS. Don't forget those federal liens. But if they did not get sent notice to the address for purposes of notice that's on their recorded lien, a mortgage is a lien, credit card judgment thing is a lien, all those, right? The HOA claim of lien, right? Wherever the address says, if the clerk didn't send them notice at least 20 days before the sale, then they can challenge the validity of the tax deed. It's not the same as a tax deed being immediately void if taxes got paid before the sale took place, right? That's why I said the first circumstance, it's void, everything is undone, your money gets returned. For everything else we're talking about, it's voidable. It can be undone if challenged. So that's the notice requirement. That second step is notice requirement for those interested parties that were supposed to be given notice. The mortgage lender, the HOA, So it's really, really important that as part of the search that you're doing, because you should be doing the search before you go and bid at a tax deed auction, that you are getting copies of the clerk's certificate of notice. That document is going to say who the clerk mailed notices to, and make sure it coincides and meets the time requirement of at least being sent out 20 days prior to the sale. Okay, so that's number two. Let's talk about the third and most complex reason why your tax deed can be challenged. And this is the number one reason why you must quiet title. You must quiet title. Clear to sell certificates are not useful for this, okay? Here's the reason why. The clerk's certificate of notice is going to say, yeah, these things were sent out to all these people. Great. That doesn't necessarily meet due process requirements. And here's where the legal challenges come in, okay? There is nuance in what happens when those things get sent out. What comes back to the clerk is big. These notices are supposed to be sent out via certified mail if they are within the United States, and another type of mail process if the parties are out of the country, because sometimes foreign nationals buy and invest in U.S. assets. That's normal. So when things get sent out via certified mail, the clerks have a return receipt form that they fill out. If things come back undeliverable, unclaimed, returned to sender, there are different legal consequences that come into play. And that tax deed can then be challenged, rendered void upon the affirmative steps of the prior owners or those lien holders of record, right? That say, hey, you may have sent notice, but because you got this thing back saying that actually didn't get to me, you needed to take affirmative extra steps, or I can challenge this. And a tax deed can be challenged up to 4 years after it's issued. That's why it's so important to have these quiet titles done, because these challenges can happen. And the nuance in what happened once it was sent out, where it was delivered, what actions that the owner of the property have, in terms of giving notice to the tax collector or the clerk about their new address for purposes of getting notifications for tax bills, all those things come into play. So the complexity and the reason why your tax deed can be challenged, the number one most painful, most legally painful and costly one is the due process challenges. So this is why we do actions to quiet title. That's why they're so very important, because instead of having those 4 years where you're kind of waiting in a panic to go, oh my God, is this going to be challenged? You name everybody involved, we serve them, we wait for them to respond, we serve them appropriately. Our service requirements in a quiet title are far more onerous than service requirements for purposes of a tax deed sale. Like what the clerk has to do is a lot less. It just is. So when an action to quiet title happens, it provides that opportunity to shorten that statute of limitations, tell them to speak up or forever hold their peace, and then really protect you by getting a final judgment quieting title. That is the way in which you are protected from future lawsuits. Why? Because at that point, it's like, hey, you had the opportunity, you were given notice. That's when you had the chance to say, hey, I wasn't properly notified of this, due process requirements weren't met. That's what a quiet title action is for. A quiet title action isn't just so that your title insurance underwriter can feel giddy and give you title insurance policy if you sell the property or if you refinance it. This is an action to deal with constitutional issues regarding due process. So it's very important that if you have a tax deed, the moment you acquire your tax deed, you retain an attorney like us to do the action to quiet title and to make sure that those constitutional issues are quashed. Okay? All right, so there you go. There's the reason why tax deeds can be challenged and why those clear to sell certificates are worthless.